especially in our internet days, the question often arises for the owners of intellectual property rights. So for example, the owner of a copyright, the owner of software rights, where to sue a perpetrator, the infringer of your rights, if that perpetrator resides abroad in a foreign country. For the European Union, that is regulated by EU law, which says that you sue the perpetrator at the place where the harmful event took place. So if you're a UK company and your copyright is infringed by a company in France, then you would sue that company in France. Now, you wonder whether there's a chance that you can sue that company, that foreign company, in the UK, in your own country. The European Court of Justice recently ruled that there is a case where you could do that, and that is when the harmful event took place abroad, but the actual damage took place in your own country. So for example, if the French company produces illegal copies of your software, sells it on to a second French company, and that second French company has a UK entity, and it's actually the UK entity that then goes on to the general market and sells those illegal copies. So the damage of the infringement happens in the UK. In such a case, the court says, you can take the French companies to court here in the UK, although the jurisdiction is limited of the English courts to determine the damage that happened or incurred here in the UK, not more. In some cases that might be absolutely sufficient. If that is the only damage that you know of that you incurred, then that is an option that you should go for. But if you know the French companies have entities in Italy and Spain, and they also sold those illegal copies on the general market, then it doesn't help you to sue the company here in the UK. Then you should stick to the general rule and sue the company in France, in this case, because that court then has the authority to decide the case for all Europe.